jurisdiction to issue the orders that would enforce the Constitution, and the first and second respondent were given an opportunity to appear before court. This court was moved under urgency through an application and petition dated 8th of January 25. The application and petition alleged that the second, fourth petitioners who were arrested by plainclothes police officers on 16th of December 24 and bundled into an unmarked vehicle had not been presented before any court or released. Their whereabouts were unknown, and their families' effort to trace them had come to nothing. So were the reports made at Mlolongo and at the river police stations. The petitioners sought, among others, an order of habeas corpus directing the respondent to produce bodies of those petitioners before court. They also sought an order directing the first respondent to appear before court and explain the whereabouts of the second, fourth petitioners. The court considered the application and issued a conservatory order directing the first and second respondent to immediately and conditionally release those petitioners. The court issued an alternative order of habeas corpus directing the first and second respondent to produce bodies of those petitioners in court and assigned a return date for that purpose, being 13th of January 25. On that day, 13th of January 2025, only the fourth respondent attended court. The rest of the respondents did not attend, and all the orders had not been complied with. The court then set the matter for further directions for 17th January and reiterated the orders issued on 8th of January 2025. On 14th of January, the first and second respondent filed this application seeking to set aside those orders, arguing that they were not served with the orders, that they were not heard before the orders were issued, and that their right to fair hearing is threatened. This court was moved under various articles of the Constitution, including Article 23, 25, 49, and 50 in the Bill of Rights. When so moved, this court has jurisdiction under Article 23(1), as read with Article 65, Sub-Article 3, to hear an application for redress of denial, violation, or infringement of, or a threat to a right or fundamental freedom in the Bill of Rights. In considering such an application, the court may grant appropriate relief, including a conservatory order. Rule 23 of the Mtunga Rules provides that despite any provision to the contrary, a judge before whom a petition is presented shall hear and determine an application for conservatory or interim orders. Rule 2 thereof allows the court to dispense with service of the application. The rule confers on the court unfettered discretion to grant conservatory or interim orders. The facts in this petition, the fact disclosed in the application and the petition were that although the second, fourth petitioners were arrested by police officers on 16th of December 2024 and bundled into a vehicle, they had not been produced in court, seen or heard of more than 14 days later, in violation of their rights and fundamental freedoms guaranteed under the Constitution. The court considered the urgency of the matter and issued orders it considered appropriate to secure the petitioner's liberty or have their bodies presented before it. Under those circumstances, the court did not have to order that the first and second petition respondent be served and heard first, as that would defeat the essence of the urgency and effectiveness of the orders in upholding the Constitution, the rule of law, human rights, and fundamental freedoms. The first and second respondents also argued that the orders the court issued had not been sought. Well, the first order to release the three petitioners immediately was informed by the fact that having been arrested and held beyond the time permitted by the Constitution, any other act of holding them was a violation of the Constitution. Indeed, the court pointed out that, and I quote, any continued holding of the four subjects is a violation of the Constitution, the supreme law of the land, and unmitigable, end of quote. Directing that the respondents be heard first would be in tandem with Constitution, will not be in tandem with Constitutional principles. The court had to act to prevent continued violation of the Constitution and the petitioner's rights and fundamental freedoms. The court also issued an order of habeas corpus directing the first and second respondent to represent bodies of those petitioners to court. The order was intended to be an inquiry to determine whether the petitioners were still alive or dead, since they were no longer being held lawfully. The order was a protection against the three petitioners' illegal confinement. Habeas corpus was one of the orders the petitioners had sought in the application, and the court did not have to hear the first and second petitioners first in the face of clear violation of the Constitution, as that would have compromised the second, third, and fourth petitioners' rights and fundamental freedoms. During the hearing, Mr. Onyamodi argued that although the petitioners did not say that the first and second respondents were holding them, Mr. Nyamodi argued that although the petitioner did not say that the first and second respondents were holding the second, third, and fourth petitioners, the court still issued orders directing the first and second respondent to release them. A reading of the pleadings, the application, supporting affidavit, and the petition shows that the petitioners were clear that the two second to fourth petitioners were arrested, quote, and abducted by armed police officers, bundled into a vehicle, and driven away. The first respondent exercises independent command over the National Police Service and performs any other functions prescribed by national legislation. That's Article 245. The first respondent's core constitutional mandate is that of command over the National Police Service and its officers. This is also reiterated in Section 8 of the National Police Service Act. The first respondent is therefore responsible for the discipline and actions of the officers under his command. You can also see Section 8A, capital A. The people who arrested and bundled the second to fourth petitioners into a vehicle were police officers under the first respondent's command. Section 24 of the Act provides for the functions of the National Police Service, which include maintenance of law and order, protection of life and property, investigation of crimes, prevention and detention of crime, apprehension of offenders, enforcement of laws and regulations with which it is charged, and performance of any other duties that may be prescribed by the Inspector General under the Act or any other written law from time to time. Other than the duties specifically stipulated in the Act, the only other duties police officers can perform are those prescribed by the first respondent. On the other hand, Section 28 of the Act establishes the Directorate of Criminal Investigations, which is under the direction, command, and control of the first respondent. The Directorate is headed by the Director of Criminal Investigations, the second respondent, but is responsible to the first respondent. The functions of the Directorate are outlined in Section 35 of the Act. They include undertaking investigations on serious crimes, including homicide, narcotic crimes, human trafficking, money laundering, terrorism, economic crimes, piracy, organized crime, and cyber crime, among others. It follows that only officers under the command of the first respondent and the Directorate, headed by the second respondent, are authorized by law to apprehend offenders. The statute uses the words apprehend, which also means to arrest. The leading The pleadings are clear that the 3 missing petitioners were arrested by police officers who are under the first respondent's command and the second respondent's directorate responsible for investigating cybercrime. The first and second respondents' argument there was no averment that they were holding the 3 petitioners, yet the court issued orders against them is implausible in the circumstances of this petition. The elite police officers authorized by law to arrest offenders. They know what their officers routinely do. An application to set aside orders calls for exercise of judicial discretion, which, like all other discretions, must be exercised judicially to avoid hardship, but not to obstruct justice. As Sir Charles Newbold, President, stated in the well-known case of Mbogo versus Shah, the test on whether to exercise judicial discretion to set aside a judgment or order is whether, in light of all the facts and circumstances, both prior and subsequent, it would be just and reasonable to set aside or vary the judgment or orders, and, if necessary, upon terms to be imposed. Mr. Nyamodi argued from the bar that he has instructions that the first and second respondents have a response. He further stated again from the bar that one of the possible responses could be that the first and second respondents do not have the second to fourth petitioners in their custody. I have read the affidavits in support of the application. There is no deposition on what the first and second response is. It is therefore not clear whether they have a response or not, and what that response is, if any. On his part, Mr. Kuria argued that it is in public interest to allow the application so that the first and second respondents can be heard. Whereas the right to be heard is a cardinal principle, counsel seemed to put more premium on the rights of and interests of the first and second respondents above those of the second to fourth petitioners, and the constitutional command regarding the rights of arrested persons to, among others, be informed of the reasons for their arrest, be allowed to communicate with an advocate and other person whose assistance is necessary, and be brought before court as soon as reasonably possible, but not later than 24 hours after being arrested. Mr. Nyamodi submitted quite correctly that the duty to justify denial of the right to be heard was on the court. Indeed, the Supreme Court observed in Sholei vs. Judicial Service Commission, and another, that the burden to justify a limitation of a fundamental right or freedom lies with the person limiting the right. The issue here is about competing rights. In one decision you see there, Jack Mukongo Munialo and others, for the Attorney General, this court observed that in considering the limitation, the court must bear in mind that there is no superior right and take into consideration factors including the need to ensure that the enjoyment of rights and fundamental freedoms by one individual does not prejudice the rights of others, which calls for balancing of rights under the principle of proportionality, because rights have equal value and therefore maintain the equality of rights. Addressing the issue of conservatory orders in Gitrai P. Tamunya, the Supreme Court stated that conservatory orders should be granted on the inherent merit of a case, bearing in mind the public interest, the constitutional values, and the proportionate magnitude and priority levels attributable to the relevant causes. All persons are entitled to and enjoy equal rights under the Constitution. No one has superior rights over the other. The court is required to apply the proportionality test, balance the rights, and where necessary, give priority to the rights of the most vulnerable person. In this petition, The fate of the second to fourth petitioners who were arrested by police officers on 16th of December 2024 is unknown. They were not produced before court as demanded by the Constitution, and their relatives do not know where they are. Securing their lives and safety, securing the lives and safety of the second to fourth petitioner was and must remain of priority to this court. In the circumstances, considering the fact of this petition and the constitutional command that an arrested person be produced in court within 24 hours, noting that the second, fourth petitioners who were arrested by police officers under the command of the first respondent have not been presented to any court of law or are released in violation of clear words of the Constitution, it will not be in public interest to allow the application. Allowing the application will also negate the essence of the conservatory orders granted and the effectiveness of habeas corpus as a constitutional remedy. The orders were intended to uphold, protect, and defend the Constitution and enforce the Bill of Rights. For the above reasons, the application is declined and it's dismissed. Thank you.
My Lord, I am grateful for the reasoned decision that you have given. I seek to make a brief application.
Proceed.
My Lord, the application I wish to make is provided for under Rule 32 of the Mutunga Rules. And my Lord, that rule envisages an application for stay of execution pending an appeal. That rule, my Lord, at sub-rule 2 envisages the application being made informally. The rule provides that such an application for stay of execution may be made informally immediately following the delivery of the judgment or ruling to the court, and the court may issue such orders as it deems fit.
You said Rule 32?
Rule 32, 1 and 2 of the Mutunga Rule.
Yes, Rule 32.
Yes.
Yes.
My Lord, the first and second respondents have wished to appeal the decision that you have made this morning in the Court of Appeal, as they are entitled to do. And my Lord, in seeking to persuade you or in considering an application for stay of execution, the court is enjoined to take into consideration two issues. First of all, is the intended appeal arguable? And will the appeal then be rendered nugatory if the stay that is sought is not granted? Well, one of the main findings that you have made in this matter is on the issue of the court's ability to determine ex parte with finality an application for conservatory orders. My Lord, there is a decision of the Court of Appeal, and that is one of the grounds that the appellant or the first and second respondents wish to take on appeal. There is a decision of the Court of Appeal, my Lord, that speaks to that point, but it speaks differently from what your Lordship has found. And my Lord, I wish to refer you to the decision of the Court of Appeal in Civil Appeal number E984. E984 of 2024. The parties are the Cabinet Secretary, Ministry of Health, who was the appellant, and Joseph Enoch Aura, and 12 others. Now, this decision of the Court of Appeal considered the point which I have just highlighted and the point that you determined. And The Court of Appeal makes an instructive finding at paragraph 57. At paragraph 57, commencing the second sentence, commenting on the High Court's ability to issue ex parte conservatory orders, it says, it is in essence that we perceive ex parte orders to be exceptional, for a very limited period, pending the hearing and determination of all affected parties. It is noteworthy that the law does not contemplate a permanent ex parte injunction. An ex parte injunction can only be temporary for a limited period and may only be confirmed after the hearing.
Na mtazamaji, ni picha za moja kwa moja kutoka mahakama ya Milimani ambapo Jaji Chacha Mwita muda mchache uliopita ametoa uamuzi kuhusiana na kesi ya Inspekta Jenerali pamoja na mkurugenzi wa DCI, na akataja kwamba wawili hao bila shaka watahitajika kufika mahakamani kama agizo lilivyokuwa awali kuweza kujibu maswali au kutoa maelekezo kuhusu visa vya utekaji nyara humu nchini. Kumbuka wawili hao walitarajiwa kufika mahakamani, lakini wamekuwa wakikosa kufika kila mara wanapohitajika. Uketo wa taarifa hiyo utakuwa unaupokea kwenye taarifa zetu za saa 1 na saa 3 mtawalia. Bila shaka mwanahabari wetu Apollo Kamau yuko katika mahakama hiyo ya Milimani akizidi kufuatilia taarifa yenyewe. Atakuwa akitujuza mengi zaidi tena kwa undani zaidi. Lakini kwa sasa